This is immigration attorney Hassan Abdullah, and I'm preparing this video to discuss the often misunderstood topic of substantial investment in terms of the E-2 visa. So it is often misunderstood because there's a specific proportionality test. So basically, to qualify for an E-2 investor visa, you have to be a foreign national from a country which has a treaty that allows those from that country to apply for the E-2 visa as a treaty investor. But beyond that, there's a question of the investment not being marginal and the investment having to be substantial. So I'm not going to cover the whole topic in general because it is a very detailed subject. What I'm specifically going to talk about is the substantiality rule. The substantiality test is basically based on a proportionality test. So if you are going to qualify for an E-2 visa as a primary investor, the investment has to be substantial. And so this is outlined in the Foreign Affairs Manual, Foreign Affairs Manual 9 FAM 4151, Note 10 is where you can see the discussion of the substantial investment, and from there you can also see more about the proportionality test. So the way it works is there's two figures that you have to pay attention to. One is how much money is invested into the enterprise, and the other question is how large is what is the cost of starting up the business if it's a startup business, or how much does it cost to purchase the business. So let's make it simple. Let's just say we're talking about purchasing a business that's valued at $100,000. So the Foreign Affairs Manual explains that the higher the cost of the investment, the bigger the amount of investment you have to make proportionally. So what that means is they even give an example of a $100,000 investment, saying that you would have to make 100% of the investment to qualify for the E-2. And for an investment of $1 million, of $100 million, they gave that example. If the business is worth $100 million, an investment of $10 million can also get you the E-2, even though that's only 10%. Now, where is the confusion that people have? The confusion that people often have is that they believe that the investor has to make that, for example, for a $100,000 business, the investor has to make 100% of the investment. Or if it's a, it's a sliding scale, so the bigger the investment, the higher percentage, the lower the proportion of investment needs to be made. So for, again, like I said, a $100 million investment, $10 million, for a $100 million business, $10 million investment is enough. So anyway, going back to the business of $100,000 or less, let's just say the business is valued at $100,000. You find it online for sale for $100,000. Does the foreign national have to actually put in $100,000? No. Actually, that's not the way it works. The way the proportionality test, so for example, if you know that you need to make 100% investment, you have to show that 100% of the value of the business has been accounted for. So even if a foreign national puts in $30,000 into an investment, a $30,000 investment into a business that's worth $100,000, and for example, a U.S. citizen puts in $70,000 into the investment, you can still qualify for the E-2 visa, because when you add that $70,000 that the U.S. citizen put into the business plus the $30,000 that the foreign national invested in the business, that equals 100% of the value of the business. So that's how it works. It's not necessary that the foreign national invests that $100,000 him or herself. So that's a very often misunderstood concept when you look at the Foreign Affairs Manual because of the ambiguity of the language there. and it's very easy to make that mistake. And many practitioners, in fact, believe that that is to be the case. However, that's not how the rule really works. Now, there is, however, a rule that 50% of the business has to be owned by foreign nationals. So, in a scenario where, for example, a U.S. citizen put a large amount of the money down versus a small amount of money put down by the actual foreign national, the ownership, if the ownership distribution of the company is such that the foreign national owns 50% of the company, even though they put less money into it, they can still qualify for the E-2 visa, because the rule is simply that the ownership should at least be 50% those of a foreign country. So hopefully that makes sense, and there's a lot more nuance and a lot more detail to evaluating whether you qualify for an E-2 visa, but at least in terms of clarifying the proportionality test, I hope that this video has done that, and just want to say thanks for watching, and bye for now.